access to that City Hall email, but I'll get them from the staff. I don't. Good afternoon, and welcome to the regularly scheduled meeting of the San Francisco Ethics Commission. Thank you all to the public for braving the smoke apocalypse and staff here to join us today. I'll call roll. Commissioner Lee? Here. Commissioner Kopp?
Here.
Commissioner Rennie?
Present.
Commissioner Ambrose?
Here.
Okay. Agenda item number 2, public comment on matters appearing or not appearing on the agenda.
Good afternoon. I catch my breath. My name is Ellen Lee Zhao. I have been working for our city as a public social worker for more than 10 years. I am also a union delegate for public employees. I have been trained to practice good government practices, and I was trained by the civic grand jury. I was the civic grand jury for 2 terms, and I am the director of public relations for the current California Civic Grand Jury. The last time I came here to speak to you was in July 20th, 2018. I report to you about government corruption, and I report to you about bribery, extortion, about public employees. Today, I am here to report to you another item. I am here to request you as ethics commissioners and, of course, public employees to review our election process. As you remember, I was one of the 8 candidates to run for mayor. I was nominated by the San Francisco Coalition of Good Neighborhoods to run for mayor because of all this government extortion, bribery, and corruption about cannabis stores throughout San Francisco. Yesterday, we had a public hearing in here, and we found out there's a lot of association between Board of Supervisors and the donors who are cannabis operators. But I'm here today just to talk about the election process. You get a couple employees in here. They walked me through the process. During the election, June 2018, I was not allowed to join more than 20 mayor candidate debates or forums in public places, such as City Hall with a lot of camera and TV and public TV, and also public libraries. I later found out many of those debates supported by super PACs, which are mostly paid by people who are controlling our city, and maybe including you, these ethics commissioners, and people who are working at ethics commissions. And those are rumors that I heard. Rumors are rumors, but you have the duty and to find out. I also found from the Election Integrity Project, our San Francisco voter system is 100% corrupt because we have 120% qualified people voted, which means dead people voted, people no longer in the address voted, unqualified illegal immigrants voted, and unqualified citizens voted. We are no longer a fair election process, and I believe you have the duty to find out and investigate this process. And Jeffrey Spear in here, I have been communicating with him back and forth with complaints. I got nowhere, so I am publicly acknowledge the problems that we are facing as public employees and as the election candidate. And you are elected and appointed. I believe you were appointed to do something about our democracy in this country, that we are protected for our constitutional rights. But that's not what I learned about San Francisco election process that I personally been through. Thank you.
Thank you.
Oh, thank you.
Commissioner Lee?
Madam Chair, I respect the public's right to express their views, but I think that it's really important for this commission to really ensure the public that until there is evidence to back up these really strong claims that undocumented immigrants are voting, I think that we need to really make the clarification that as far as we're concerned, as of today, there is no evidence that undocumented persons were voting. And to clarify, I think this was the first time in San Francisco history that immigrants were able to vote in the school board races. So I just want to make clear that if people have heard that non-citizens are voting, that's because legally non-citizens who are immigrants in the city were allowed to vote for the first time in the San Francisco Unified School Board race.
Commissioner Kopp.
Well, I'd like to ask, yes, do you have, step up to the podium, please.
Yes.
Do you have facts to support this in the form of documents? Or?
Yes. It is supported by the Election Integrity
No,
Project.
all you have to say is yes or no.
Yes.
You do.
Yes.
Have you taken them to the district attorney?
I believe the district attorney is involved at this point.
What does that mean? No? You
Yes.
haven't?
Yes.
Well, I would recommend that the conduct you've alleged and described would constitute crimes.
Yes.
And crimes are the responsibility of the district attorney.
Yes.
And I recommend that that's where you lodge your allegations.
Yes. But I personally believe that you also have the obligation as an ethics commissioners because you oversee the election process and you're giving money, public money to the qualified people for matching money. And the process itself is supported and bought.
Through the chair to the executive director, is that the responsibility of the Ethics Commission to ensure legal voting?
Our responsibility is for public financing. We don't have oversight over voting.
Thank you.
Well, thank you.
Thank you. Any other public comment for agenda item number 2? All right, moving on to the consent calendar items. Excuse me. Agenda item number 3, draft minutes for the Ethics Commission's October 19, 2018 regular meeting. Excuse me. Is there a motion to approve?
I would so move.
Second.
There's a second. All in favor? Aye. Opposed? The motion carries unanimously.
Don't you need public comment?
Oh, I'm sorry. Yeah, public comment. No public comment. Agenda item number 4, stipulation, decision, and order in the matter of Mark Leno and Mark Leno for Mayor 2018. Ethics Commission case number 1718-076. Yeah. Jeff, did you want to take us?
No, because this stipulation appears on the consent calendar, staff have not prepared to present it. The commission may make remarks and invite public comment.
Any comments from commissioners? Otherwise, any public comment on agenda item number 4?
Let me just ask a question about it. Is the only violation that the quoted language on page 2 was not included in the disclaimer? In other words, if financial disclosures are available at sfethics.org, is that the only violation that they just failed to put that in?
Yes, that's correct.
It seemed like such a picayune violation for $1,000, but it's all right.
Public comment? Okay, there Being none, I move to approve the stipulation. Is there a second?
Second.
Okay, all in favor?
To clarify, this stipulation has already been approved by the commission.
Oh, right, okay, so we don't need to do anything?
Correct.
Great, okay, thank you. Moving on to agenda item number
Why
5.
is it on the calendar? Why is it on the calendar?
It appears on the consent calendar so that members of the public
Can
may
comment
view the
on that.
stipulation and provide comment if they wish to. It is approved ahead of the meeting by virtue of none of the commissioners having requested to calendar it for separate consideration. I don't know if we invited public comment on this item.
On
We
the
did.
consent
Okay.
calendar.
Okay, agenda item number 5, discussion and possible action on draft regulations and ordinance regarding the public financing program.
Thank you, Chair
Mr.
Chu and Commissioners. Pat Ford, Senior Policy Analyst. Item 5 is a follow-up to the public financing review project that you heard at the last meeting in October. And at that meeting, I presented to you a set of recommendations that were based on my review of the public financing program. The recommendations came both in the form of proposals for new regulations or revised regulations, and separately for new or revised ordinances, all addressing the public financing program. So you voted that you wanted to move forward with those recommendations. So working together with the City Attorney's Office, this agenda item 5 presents to you as attachment 1 a set of regulations to implement the recommendations that you saw last month, and as attachment 2 a draft ordinance to carry out the legislative recommendations from last month. This cover memo briefly restates what those recommendations were. The bullets provide a rationale, the main rationale for each of these changes. A few things that I wanted to highlight as well. If you look at item 7 under the recommended regulations, this pertains to creating through regulation a standard of review that the commission would use when hearing appeals from candidates who had been denied eligibility in the program. Currently, there is no standard of review. The code creates a certain limited right of appeal that candidates could come to the commission, but it doesn't say what the commission should do in reviewing such appeals, whether or not they should overturn staff's determination. So this is an attempt to give some kind of framework for analysis for both the candidates presenting the appeal and for the commission hearing the appeal. But what I wanted to highlight was that Commissioner Ambrose had raised the point during the last meeting that perhaps another standard of review would be more appropriate. So in working with her and with the City Attorney's Office, we have an alternate standard of review that you might consider. I'll put it on the projector. So what's currently in the ordinance, or rather the draft regulations, is attachment 1, is an arbitrary and capricious standard that in reviewing any determination made by staff, when staff was reviewing the candidate's qualifying request, that the commission would only vacate the executive director's determination if staff's review is arbitrary and capricious. That's what's in the regulations now. What I'm showing you here in the projector is a different standard. This standard would give less deference to
I'm sorry,
staff.
Mr. Ford, could you clarify that? Could you repeat that? That the current regulations, the standard is?
So in the existing regulations that are law in
Yes.
the city and county, there's no standard.
There's no standard.
No standard exists. In the draft regulation
Okay.
that's attached here is attachment 1, and what I had originally proposed, this would create an arbitrary and capricious standard.
Okay.
For all staff determinations would be reviewed by the commission under the arbitrary and capricious standard, under this proposal that's attachment 1. But what's here on the projector is an alternative that you could consider. This would give less deference to staff determinations. It would be essentially a bifurcated approach where for questions of law, no deference would be given to staff determinations. The commission would review questions of law de novo. Essentially, you would make your own determination. disregard or pay no deference to staff's determination. For questions of fact, they would be reviewed under basically a clearly erroneous standard, where the commission would follow staff's factual determinations, overturning them only if they were clearly erroneous. And Deputy City Attorney Givner was kind enough before this meeting to help prepare the language that you're seeing here. And he's advised that you could act on this today, even though this has not been copied into the actual text here. By motion, if you wanted to adopt this standard instead, you could do that. So I just wanted to highlight that, put this up so that you and members of the public can see this. It is an alternative for you, should you choose to take that route instead. One other thing I wanted to highlight is that there is a third attachment to this memo that is an ordinance. This ordinance would essentially create a bar to certain individuals that would prohibit them from obtaining public financing. Originally, I had put this in as a proposal coming from Supervisor Safai's office. This was at Commissioner Kopp's request that we include this proposal as part of the Policy Division's review of the public financing program. Supervisor Safai's office has not presented any further clarifications about this ordinance. They have communicated that essentially they will leave it to the commission's judgment whether to pursue this, and if so, how to resolve some of the outstanding questions about it. I asked Deputy City Attorney Shen to prepare this as a separate ordinance so that you have some flexibility. If you want to move forward with it as a separate ordinance, you could do that. If you'd like to fold it into the same ordinance as the main public financing ordinance here, attachment 2, you could do that as well. So you have some flexibility. You could also move forward with only one of them, but I had them done separately so that they're not necessarily joined at the hip. So you have some flexibility. I just wanted to point that out.
Mr. Ford, no one from Supervisor Safai's office will be here today to give us a background and their support and reasons for wanting this change to the ordinance?
That is correct.
And that you noted that any questions that we have, or if there are areas of disagreement or concern, that we would be free to modify his proposal?
I think at this point, it's everything's on the table. It's basically before you without any particular recommendations or clarifications from the supervisor's office, and it's up to you.
And did he communicate what his expectations are regarding the next steps, like if from and after the time that an ordinance is or is not approved, like is his expectation that it would go back to the Board of Supervisors, go on the ballot, or it wasn't stated?
No, that was not discussed.
Commissioner Kopp, do you have?
Yeah, having introduced this at the commission, I have a comment, and then I've got a question for a recommendation. Questions have been raised that mean to me further reflection and some further research on other jurisdictions' practices are justified, even mandated. One of the questions is if, for example, the commission adopts a penalty for violation of the public financing law, failure to file a document or fail to file a complete document, and there's a monetary penalty, and then there is a law which prohibits the object, the candidate of that penalty, from participating in public financing as a candidate in the future for any given period of time. Could be 2 years, it could be 5 years, could be 3 years. Doesn't that constitute a double penalty? And if it does constitute a double penalty, secondly, Is that justified in terms of respectable public policy and administration of justice? Secondly, the respected longtime president of the Friends of Ethics, Mr. Larry Bush, has provided yesterday a list of other violations of our governing law, which logically could also be a ground for prohibiting participation in public financing. And I've asked Mr. Pierce to examine those, but that's a question for the commission to determine. Should it be for other violations of law than violating some part of the public financing law? And those are meaty questions to think about. And for that reason, I'm inclined to make a motion to continue that until our next meeting. The purpose of that motion would be to ensure staff research with respect to both questions, including the issue of including other offenses. Before making such a motion, I want to ask, what's the advantage of both of these being merged into one? What's the disadvantage? What's the advantage of proceeding with the penalty ordinance, as I'll dub it, alone? And does that involve legal effectiveness in time for the 2019 municipal elections?
So I think from a process standpoint, we have two options of enacting an ordinance. One would be to put it on the ballot. There's currently no June 2019 election scheduled, so the next regularly scheduled election would not happen until November of 2019, so a year from now. The alternate, and so obviously if that were to go onto the ballot, this ordinance would not impact the mayoral race or any race until from and after the effective time of if it's approved by the voters and it goes into effect, say, January 1st, 2020. If we go the legislative route through the Board of Supervisors, it would need to be approved by 8 out of the 11, and then it would, and if they make changes to what we send to them, it would have to then come back to us as well. And that process, I don't know, Pat, if you've had any conversations with supervisors, could give us, and also there will be 5 new supervisors being seated in January. 3, sorry.
Well, I realize that, Madam Chairwoman. My objective is to have it take effect in time for 2019 municipal elections. And that's why I'd like those questions answered.
So to your question of the relative pros and cons of moving the two ordinances together, separately or together, if they were conjoined into one ordinance, there's going to be one ordinance, so it'll be one thing to track, one thing to go through the Rules Committee, one item to go before the board. So there could be a potential factor of efficiency just by there only being one rather than two. If you have two things, they can take different courses. Different supervisors may take interest in one over the other, and they may, one may go faster or one may go slower. It could happen. However, if they are put together, you will bind the fate of the reforms to the public financing program to this penalty proposal. And if the penalty proposal holds up the ordinance, the solitary ordinance, it will also hold up the reforms to the public financing program. that could be a downside. Potentially, if some supervisors were to view the penalty proposal, as you described, as being a double penalty, or if they were to view it as being politically motivated or as bad policy or what have you, it could slow down that single ordinance as a whole. It could also happen that in committee or at the full board, they decide to remove that provision from the ordinance, in which case it would not be able to take effect without coming back to you, because you would have to then approve that amended ordinance. However, if you move the two ordinances separately, if the board or a committee thereof were to take issue with the penalty provision, they might not take issue with the reforms to the public financing program. That ordinance could move ahead more expeditiously. If that penalty proposal ordinance were to take longer, it wouldn't have an effect on the public financing reforms. That's probably the biggest pro for having two separate ordinances.
I neglected to include one other factor reflected in the privileged and confidential memorandum of law from Deputy City Attorney Shen dated November 13, 2018. The issue discussed in that memorandum is constitutionality. And I don't know how far I can go in comments about that, but that's also a factor in terms of its treatment by the Board of Supervisors. Do you have any particular thought on that?
I think my overarching thought, without getting into the merits of the constitutional question, is that the board would probably seek its own opinion from the city attorney's office. I don't know if the...
How are they going to change the Arizona case?
Oh, can I jump in?
Yeah.
Deputy,
All right, I have enough information.
Deputy City Attorney John Gifner. Without getting into any of the merits, of course, many regulations and proposals that this commission considers involving campaign finance implicate constitutional questions. Our office often advises both this commission and the Board of Supervisors on those matters whenever you're considering a proposal to amend the public financing program or any other change to the campaign finance reform ordinance. When that happens, when the Ethics Commission adopts a proposed ordinance and sends it to the board to consider, our office gives the same advice to the Ethics Commission and to the board, and then ultimately to the mayor when that ordinance passes the board, so that all decision makers are on the same page about the legal issues.
So specifically, though, from a process standpoint for this commission, if we had concerns and wanted to discuss them regarding the constitutionality of the proposed ordinance, whether it is Safai's or the commission's ordinance, how and when could we go about doing that?
I think that the simplest way to discuss legal issues confidentially, if one or two supervisors have questions, is to speak with my office, with me, or with Mr. Shen.
If we as commissioners
if the commission wants to have a discussion about legal issues and there's a significant risk of litigation, then the commission can schedule a closed session to discuss those issues in closed session, to receive legal advice and discuss that legal advice in a closed session. Not at today's meeting, but at a future meeting.
I see. Okay, thank you. All right. Well, speaking for myself, I, for one, would like to have that discussion. It seems like Commissioner Kopp, you also would like to better understand, in addition to the items that you enumerated.
No, I understand the issues fully, and I'm not going to express my opinion as to what'll happen. I'm not going to prejudge that. I don't get paid to do that. I think a confidential report or closed session for that purpose is justified. I mean, I've expressed myself in this commission before. I did last month. The fact that something might be unconstitutional doesn't dissuade me, so long as it's a reasonable legal issue which is presented, and it's not completely governed by precedent against it.
So, Director Pelham, could we schedule that on at the December meeting to have a closed session to discuss these constitutional issues and answer any questions that commissioners may have, and then have a more free discussion with either you, John, or with Andrew?
It's certainly schedule that if that's the commission's preference.
Can I make a...
Yes, Commissioner Ambrose.
But getting back to the more pragmatic question, am I correct in understanding that the first ordinance that's being proposed by staff doesn't raise those legal issues and don't require the answers to the questions that you pose? Is there an interest in moving that forward just in the interest of time? I mean, the board can always merge the two for hearing once the second one catches up because they're related subject matter, so we could at least, if I'm correct in the proposals that your staff is making and that we considered at the last meeting on what is principally cleaning up the whole determinations of raising the ceiling for expenditures, which I think we all agreed was an unnecessarily laborious imposition on staff and unnecessary for protecting the public's interest. I would be in favor of focusing on that first ordinance and waiting the hearing in December on the penalty ordinance, as you called it, if there's an interest in doing that.
So I think the ordinance that appears, draft ordinance that appears as attachment 2.
Attachment 1 is what I'm talking about. Oh, attachment 2, yes.
Right. Attachment 1 are the regulations, and I don't believe the city attorney's office has raised any red flags about the regulations. So I think if you wanted to move ahead with the regulations, that would not require a closed session to discuss the cautionary memo because it's not pertinent. But as for the ordinance, I'll ask the city attorney, Deputy City Attorney Givner, but I think that only the third of the enumerated recommendations in the memo are what the cautionary memo is focused on, and that is changing the definition of total supportive funds to count candidate expenditures rather than contributions. I'm not sure if you're suggesting, Commissioner Ambrose, that we remove that and bifurcate that into a separate ordinance and move ahead with the other legislative recommendations, or if you were referring only to the regulations that are attachment 1.
I'm asking the question because I am not. I wasn't clear on what we needed further enlightenment on. So
I think Commissioners Kopp and Chu are proposing a closed session on attachment 2, the larger public financing proposal.
all right, that's fine. I'm prepared to wait.
And to the extent attachment 3 raises similar attorney-client privileged legal issues that we need to discuss as well, as Commissioner Kopp had raised.
And just to follow up then on, and I would be prepared to move forward on the regulations today if that allows us to finish up one piece of business subject to our discussing the standard of review. And then finally on the attachment 3, the penalty ordinance, I believe that Commissioner Kopp was asking for further investigation into the, quote, double penalty issue. In that regard, one of the concerns that I had was whether or not there's a problem with retroactivity of this penalty, so that at the time that the original violation occurred or was alleged to have occurred, the candidates were not aware of these consequences, that they would never be allowed to obtain public financing again. And I know that retroactivity and penalties is something that is potentially problematic. And so when you're looking at that issue, I'd like to hear what your views are on the legal issues around that question. The other thing, I think we need to make it clear that it has to be a final audit finding, not something that was overturned by the court or subject to appeal. But so with that, going back to the regulations, I'm ready to.
As part, if we're adding to the list of analysis, I'd also like to get staff's view on a final audit finding or an enforcement action as the trigger for the bar penalty, is however you want to phrase it. Then I'd like to ask my fellow commissioners their views on a bifurcation process. We're already bifurcating our own ordinance to the extent that we've got regulations, and we also have legislative changes that we will be taking up at our next meeting. But in the interest of time for our December meeting, and we do have time today, and it is on the agenda, two questions. One is, do we want to move forward with reviewing the regulations, in and of themselves, and put that, if it's approved, that can be approved and incorporated into whatever we determine to do at our December meeting. And then secondarily, to Commissioner Kopp's question and the view back from staff of tying the two ordinances, the penalty ordinance as well as our own commission ordinance together, is there a view amongst commissioners how you would like to proceed with that? Anyone? I mean, for my own view, I would prefer to keep our commission ordinance together if we have our regulations and our legal changes, and that can proceed as a package with the Board of Supervisors, and then the penalty ordinance could be on a separate track because they could always be merged at a later date. But this way, the regulatory reforms, which I think are much needed and have been very well vetted, both in interested persons meetings and here at the Commission, and would be, I think, very welcome changes to the process and could be implemented in time for next year's mayoral race and other supervisor races, that we not have them be held hostage to a process that could take longer with a more substantive penalty ordinance.
Madam Chairwoman, all right, I don't think they should be bifurcated unless there's something more compelling. I do think we should have a closed session on the ordinance, attachment number 2. I don't think the regulation should be bifurcated from attachment 2. I'm going to make a motion to continue attachment 3, that ordinance, to our next meeting. And I would also like a closed session to discuss the constitutional point with the city attorney and our council.
So yes, we are going to do that at our next meeting, and so we
Next meeting?
That's on
Well, then I'll make a motion to continue the whole item till the next meeting. And I'll withdraw the motion to just continue the attachment 3.
I can make a comment through the chair. These regulations only affect, these draft regulations in attachment 1 would only affect existing law. If you were to pass and the Board of Supervisors were to approve an ordinance, another set of regulations will have to go through to update the regulations to conform them with the new code changes that you make through the ordinance. These regulations can be done by themselves. That's the way they're set up, that these are two separate things. In other words, they don't have to necessarily be conjoined. So I just wanted to raise that so that you're not surprised down the road if when an ordinance is approved, more regulations appear. Because, for example, if you change the definition of total supportive funds, there's a regulation about total supportive funds. We'll have to change that. But these regulations that you have before you today don't do that for this exact reason, that we can't know for sure what will happen to the ordinance once it leaves you. The board may not approve it. So we can't pass regulations today assuming that the ordinance will go through. So I don't know if that affects your calculus on this, but I wanted to point that out.
I think I did understand that, and that's what I'm concerned about. Although you're pointing out there is no election in June, it's not quite as urgent as all that. But I do want to make sure that by the time the first deadlines come around for people to seek public financing for November, assuming that there are eligibility in November, that it's clear what we're proposing here, that you're not going to be able to have your submittals reviewed until you filed your statement of participation or whatever it's called. So, I mean, I think these regulations really just literally deal with the appeal process we had before, et cetera. So as long as we can get that done by April or May, we're probably okay.
And if I might add, Chair and other commission members, one of the things I think it would be helpful is if the commission is comfortable with the regulations to help clarify the public financing rules, it will be most helpful to have that information out sooner rather than later for candidates because, as you know, I'm sure 2019 is actually just around the corner. So as we have as much lead time as possible to update guides and materials and training for candidates, that would be most helpful, I think, to them as well.
Right. And so if you look at your staff report, your regulatory recommendations, that's just basically the first page of the memo 1 through 7 focuses on how you propose clarifying, not changing the law, but just clarifying what you can submit to show that your contributions were from qualified residents, when we'll hear an appeal, for example, proposing we wouldn't hear an appeal when someone missed a submittal deadline because the clarification that there wouldn't have been a final determination by the executive director because there's nothing before them. That's one of your recommendations. You know, so I don't know if I'm happy to do it at the next meeting. I'm just a little worried we're going to get jammed up at that meeting. If we had time to look at those 7 regulations today and just cut that loose, I'm all for that. If not, I'm happy to take it up again.
No, I would agree with you. If we could just discuss these today, take public comment on these today, then we will not have to do that in December.
Okay.
So I will begin in that item number 7. So Commissioner Ambrose, if you could give us a little background on the standard of review and your thoughts on staff's recommendation of on appeal, the commission being able to review questions of law de novo, and then questions of fact that there's a clearly erroneous standard, versus the current draft, which is arbitrary and capricious.
Thank you. I'm hoping that the revised staff proposal also resonates with the commission in terms of how we saw our role in the appeals that we actually heard. That I consider on a factual issue, was somebody on their long list of contributors a resident or not a resident? What I was looking for when on the appeals is if someone could present evidence that they were not given credit for a contribution because for whatever reason staff erroneously deemed them to be non-qualifying, they present evidence that they are, and suddenly the $100 that person gives goes in the other column. I think that that's an appropriate role for the Commission on Appeal to give the city an opportunity to correct a mistake, you know, if there's more evidence. On the legal issue, I also think it's appropriate that the commission under the charter is the entity that is making a determination as to what the ordinance, which, the commission would have previously reviewed and had some insight into what it was intended to mean, as opposed to having deference to the staff on that question. And so to that end, I would support the proposed revision that on questions of law, the commission sits de novo and exercises its own judgment on what the law requires, and on questions of fact, we would defer to the staff's careful review of the submittals. We're obviously not going to sit here and go through everybody's documentation, but if on appeal somebody shows that there was clearly an error, we would have the opportunity to correct that and move forward. So that's that. And arbitrary and capricious, frankly, I'm going to take the position that our staff will never, ever be arbitrary and capricious. And so I don't ever want to be in a situation to find out that they made a mistake. And in order to correct it, I have to somehow stretch and conclude that they did it in an arbitrary manner. Sometimes mistakes just happen despite due diligence. So that's why I didn't like that standard.
Other comments? Okay. Thank you. So where we are then is that for attachment 3, we will hold that over to the December meeting, and that staff will prepare and work with the city attorney's office for a legal briefing in closed session on those issues that were raised both by attachment 3 and with attachment 2. Okay. So we'll take public comment now on agenda item number 5.
Well, San Francisco, we have a lot of residents, but at the same time, our public employees, 50%, they're not living in the city. So we see a lot of problems the city run, include the election process. And I was sitting in there and reading the document because I went through the process. Any new people who are running for office will not able to compete with incumbents and will not able to compete with people who are related, current electoral officers. Last month, you have a couple people protest. One of them is Luann Boston, that you guys rejected her. Some months ago, Angela Alialto, the same thing, rejected. The reason I brought this up in here today is because I work with enough public employees to talk about how we can improve the process. So then other people, especially new people, never run for office, will know what to do. I'm here to ask you, if you change regulations, a couple areas, to put trainings for new people in that sense, just for the purpose of public finance. Because I personally did not know, and I personally did not go through that process, that I was trained and guided to get help. Same with Luann Boston. Now, I don't know about Angela Alialto, because she is a politician. Now, the other one that I've seen from this process is that if you can create some caps, our public employees, that we work so hard that we don't get any assistance for child care, any assistance for any public stuff, for anything else. But anybody who's incumbent, who is already related to Super PAC, they are the one controlling your life, my life. San Francisco has not been better for many years. We had more people die on the street. We had more people overdose and dying on the street. It's because you, ethics commissioners, overlooked the problems that people running for office. Earlier, I testified, the money, the Super PAC people, they are the similar PACs from similar people supporting our city government who are bought our electoral officers. And you, I'm not sure if you live in San Francisco, but I myself live in San Francisco for more than 30 years. I've seen repeat problems. Our election process has been corrupt and has been bought. The people who really want to make change cannot be elected. It's because of this process, public finance. If you want to help people, give them training specifically on public finance. The other one is max it out. For example, mayor, the mayor's position, and board of supervisors who are incumbents already, we should not be having the same privilege for these people because they went through the process. That is called government race and government inappropriate public practices. I said that because I've seen enough situations that people complain about the process, but the Ethics Commission is not stepping up. Now is the time that I'm glad that you guys talking about reforming some of those complaints so you can help the people really want to improve your life, my life, so our car break-in will be reduced, our homeless people can get housed, and other teachers can be appreciated for what we do instead of people over and over paid by the people running the super PAC. It is the same money. You have different PACs, different people. It is the same money going in plus public finance, and it's not fair. And thank you for this time.
Madam
you.
Chairwoman,
Yes.
because these proceedings are televised, I want to clarify a point raised by the witness. Every member of the commission is and must be by law a resident of the city and county of San Francisco. And secondly, although it's beside your question, nobody on the commission is paid a penny to spend time, attention, and effort on responsibilities.
Thank you, Commissioner Kopp. And Mr. Ford, can you clarify what efforts will be undertaken by, what are currently being undertaken by the commission to provide training to potential candidates and their treasurers, and as well as what we plan to do on a go-forward basis after the regulations are implemented and, you know, possibly a new ordinance is enacted?
Sure. So we already provide trainings, in-person trainings to candidates and treasurers. Trainings are mandatory. We don't go into great depth about public financing, but we definitely do include, at the minimum, just a reference to it and a link to the supplemental guide for mayoral candidates and the supplemental guide for supervisorial candidates that contains all of the relevant information. And we let people know about the deadline for the statement of participation, basically just kind of the introductory item. So anyone who comes to that training will at least be aware of the program and know where to get the resources. Then once they start to pursue the resources, our office is available during all office hours for questions. We got a lot of questions about public financing and always available to talk to people. We're also going to be revising the guide. We'll have to revise the guide if any of the recommended changes are made, just because it will change what's currently in the guide. But I think as part of the larger reexamination of the program, we'd like to change the guide anyway. I think we'd like to go back, look at the guide, regardless of whether or not you decide to move forward with these recommendations, and find places where people have criticized it as not being clear enough, not being thorough enough, and try to address that. Try and make it the absolute most useful document that it can be to people, while still keeping it at a manageable length, something that's not a tome that candidates will be unable to work through, because that obviously would be counterproductive. But I think finding a way to at least provide information that others have found to be lacking will definitely be part of this project.
Yes, well, I would strongly encourage you and Gaia 3 and the great team behind both of you to incorporate the feedback that we've received from the many stakeholders in this process, in particular those candidates who have been running and the frustrations and difficulties that they have experienced in finding out when the deadlines are, where they actually have to file, how they need to file, so that it can be a less painful process for everyone involved. That would be you know, my hope for an outcome. Thank you. Any other public comment? Okay. Moving on then to discussion, agenda item number 6, discussion of monthly staff policy.
Well,
We
wait
need
a
a
moment.
Oh, sorry, do we have to vote?
Are we moving
Are
to
we mo-
continue this? Do we have to move?
Do we have to move?
I would make maybe I missed it. So we're just going to talk about the regulatory recommendations and just take them up in December for a vote along with the other
All right,
parts of
second
it?
the motion.
I was actually asking a question, but you could turn that into a motion if that's what you want to do. I'll go along with it. That everything on item 5 is going to get put over till December. I would like to bifurcate the regulations and go ahead and approve them today. But if everyone else isn't ready to do that, then
I'm ready to approve the regulations.
you want to,
So,
I am not.
okay. All right, so
Is there-
then that would be the motion to continue.
so are you making a motion to,
No, I think if folks aren't ready, I'm happy to just move the whole thing to December, and we'll consider, I think there's plenty of time still to get it in your brochure, and then if we need to double back, we can do that as well. So I'm going to sit back and let Commissioner Kopp make the motion.
If I can get a clarification, I thought the motion was to continue attachment 3 only, and we were going to proceed. I thought we were going to,
I construed Commissioner Ambrose's motion to be to continue the item. In fact, the motion may not be needed, and I think that's why the chairwoman proceeded to item number 6. Do
So-
we need a motion or not? Because it only refers to possible action, it being the agenda.
so I think just to recap, what the commission would like to do is to take attachment 2 and attachment 3 and discuss them in December in a closed session in order to go explore and discuss all of the legal issues that may be raised. The regulations, which are attachment 1, I think have been
To vote
discussed,
today.
and they could be continued to December, or they could be voted on today.
I would make the motion that we would vote on attachment 1 today and continue attachments 2 and 3 to the next meeting.
But I think
I'll
Commissioner...
second that.
Okay. But I thought Commissioner Kopp was saying that he wasn't prepared to do that. I mean, my main concern is that if this regulations come back to us, then I would like to make a motion to substitute the proposed standard of review as per the language that was placed on the monitor with de novo review for matters of law and clearly erroneous being the standard for matters of fact, so that at least if this is republished for public review at the December meeting, that everyone in the public has the benefit of understanding that that's the language that we would be acting on, and in deference to the commission. There's no hurry. We don't need to rush this through if everyone's not ready to vote on it.
I believe there was a second, but
I agree.
you are proposing then a friendly amendment to the motion to approve
I'm
these
sorry, you did
attachment
second
1
that.
with the standard of review changed to de novo review of legal issues and clearly erroneous for issues of fact.
Yes, absolutely. I would move that as an amendment to the regulations before we vote on the on the package of attachment 1. Whether we do that at this meeting or at the next meeting, I do want to amend it to put in the language that staff recommended as the revised standard of review. And I'd ask for a second.
I'll accept that. I'll accept that amendment to my motion that we approve attachment 1 as amended based on the language that we were shown by staff.
Thank you.
Okay. Commissioner Kopp?
I thought Commissioner Ambrose's statement was to the effect of giving the public an opportunity to comment and review that amendment. I mean, de novo is not a trivial principle. And I would think people might have opinions about it.
Commissioner Lee?
Thank you, Madam Chair. I think my support for taking action on attachment 1 today, there are a couple of reasons. Number one, I do agree with the director that the more time to allow the public to get used to the new regulatory changes, and more importantly, for the staff to prepare for that. We are hitting the holiday season in December, and much of what's included in attachment 1 was already discussed at the last meeting. So it was based on the last discussion that we had that the staff had prepared for attachment 1. So I do think that the public had the opportunity to comment, am I right, at the last meeting. So these, the proposed regulatory changes were reflected by the Commission's comments as well as a public comment. Am I?
That's correct, but I think the point from Commissioner Kopp is, and that I was making as well, the public, notwithstanding that we are advised that the change in the standard of review is within the scope of the notice, that it is a change that we've discussed here and given public comment, but it would give people an opportunity to actually read the language and review it. And so in the just interest of transparency and comedy, I guess I am arguing that we just make that change and bring the regulations back in December. You can put it on as a separate item so it doesn't get, so it's clear that it can move forward independently from the legislative recommendations. It's separate and apart from recommending that we change the law, which is a much more complicated process requiring, board involvement. So just to get along and give the public the opportunity, I would say that would be, I'm not sure we are on the motions, but I would be inclined to support just putting it over till December.
Okay, so the
The
current,
first thing we have to do is adopt the amendment.
okay, so
We had a second.
the current pending motion was to approve attachment 1 as amended with the new standards for law and for fact. And that was seconded. And so now Mr. Givner, do we need to have a separate amendment to approve, a separate motion to approve the amendment?
You can take it either way. You can, as Commissioner Kopp suggests, take a separate motion to approve the amendment and then resolve whether you're going to pass the amended regulations today or put them over till next month. Or you could act on what I understand is now, I don't remember if it was Commissioner Lee's motion or Commissioner Rennie's motion, to pass them today with the amendment. So you could do it in 2 steps or in 1.
So why don't we take it in 2 steps? So the first motion is to amend attachment 1 to provide for a standard of review of de novo for fact and clearly erroneous for issues of law. Is there a second?
I'm sorry.
Is there a second?
No, I made the motion. I'm not seconding it.
Okay, so there's a second.
I'll second it.
All right.
All in favor?
Aye.
Aye. Okay, the motion passes unanimously. So the second motion then, Commissioner Ambrose, the original motion had been to approve those today. Would you want to go forward with that, or would you like to amend your motion to hold it over to?
I think that was actually Commissioner Rennie's motion.
Commissioner Rennie, you had moved to approve these
My
regulations
motion,
today.
the motion I make is that we approve attachment 1 as amended.
I'll second.
There's a second. All in favor?
Aye.
Aye.
And I'm going to,
Those opposed?
No.
no, I'm going to,
Okay. So the motion carries 3-2. Agenda item number 6, discussion of monthly staff policy report.
Thank you, Chair. Item 6 sets forth the Policy Division's report on activity over the last month. I won't go through it. I think it's best to just make myself available for questions. You'll see that the Public Financing Review Project that was at item 5 appears here, and otherwise, there are items that are not presently before you today. Be glad to answer questions about those, should you have any.
I just had one question on page 3, item B1, the whistleblower ordinance. I
Yes.
see that the Rules Committee meeting on November 7th was canceled.
Correct.
Is there a date for the next meeting?
I believe that there is supposed to be one more meeting before the legislative
holidays?
session ends.
Okay.
I don't know the exact date of it. I am regularly checking in with Supervisor Safai's office. He is the chair of the Rules Committee, and trying to get an update on whether or not this item will appear at that meeting and what the date is going to be. And so far, have not gotten confirmation on that. So I will
Okay,
keep you
so
updated.
it's possible that it could be heard in this legislative session, but it's also entirely possible it will be held over, it will be pushed to next year.
That's correct.
Thank you. Commissioner Lee?
Thank you, Madam Chair. I just have a question to Mr. Ford. Given the whistleblower ordinance as well as the ethics reforms ordinance, both authors are slated to leave the board at the end of this year. So do you have any idea whether someone else has picked up the sponsorship of these bills, or where is it going?
Here, I couldn't hear you too well, Commissioner.
The whistleblower proposal as well as the Kim proposals, since both of the sponsors will be leaving the board at the end of this year. So do you have any idea if someone else is going to pick up the steam, so to speak, or what's going to happen to them?
Yeah, on whistleblower, I don't know. That's a really good question. I'm not sure what exactly would happen if President Cohen were to leave the board and that item were still
She is leaving.
outstanding. Right. Well, and the item were still outstanding. I'm not sure. Maybe Deputy City Attorney Givner can speak on that.
Sure. So there's a process when the sponsor or all the sponsors of a piece of legislation leave the board and the legislation is still pending. The clerk will reach out to all the supervisors, those remaining and the new supervisors, and see whether anyone else wants to take up sponsorship. If one supervisor says yes, that proposed legislation will stay alive. If no supervisors want to assume sponsorship, the clerk will file the item and it won't move forward.
Thank you.
I think as a follow-up to your question, if that were to happen, I think that we would probably reach out to supervisors and see if we could find someone who's interested in picking this item up rather than just letting it float on the wind.
Thank you.
Yes.
Madam Chair.
Commissioner Comp.
Refresh my memory. I'm looking at the summary of bills watched. Did the commission take a position on each of those bills,
No,
or none of them?
none. This comes from the FPPC. This is the
I know
FPPC's list.
I know the origin
Right.
of it.
So when this says
But
support,
why
that's
are
not
we-
this commission.
Huh?
When it says support, that's not this commission. That's the FPPC supporting.
I remember a year ago discussing this subject of following bills which affect our subject matter and taking positions on them. Has that been abandoned or never instituted?
I think that this list is made available to you in part to keep you apprised, so that should you wish to take a position on it, this is to let you know what bills there are that you might want to take a position on.
Okay, so starting in January or February, when bills are introduced, we'll be informed in the meeting packet.
I will continue to provide this list.
Thank you.
Although, just for the commission, for the record, the commission actually cannot take a position on state legislation on behalf of the city. Only the Board of Supervisors or the
That's
State
true.
Legislation Committee, which is another city body.
All
can
right,
take a-
so we
but you
can
urge.
recommend it.
Yes.
I think we should, if inclined and interested to do so.
Okay. Any other comments or questions for Mr. Ford? Public comment on this item? Okay. There being no public comment, we'll move on to agenda item number 7, discussion of monthly staff enforcement report, including an update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting.
Thank you, Chair Chu and Commissioners. You've seen the report. This month's enforcement report is relatively concise. I'll keep my remarks similarly. I'll just observe that there are new graphics for you and the public to be hopefully better apprised of the complaints that remain before the Enforcement Division, both in terms of those that are in preliminary review, which is the process that we have described as triage, and those complaints that are under open investigation. And I would like to acknowledge staff of the Electronic Disclosure and Data Analysis team for making those graphics available to you. Apart from that, I'm happy to receive any questions that commissioners might have.
Any questions? No, I just wanted to commend you and the team for making progress against the big backlog of cases, and also they keep coming. So keep it up. Well done.
Thank you.
Public comment on agenda item number 7? There being none, we'll move on to agenda item number 8, discussion of the executive director's report.
Thank you, Chair Chu. This report just had some brief updates for you. We wanted to just give a quick snapshot of some of the information from election 2018 in terms of the scope of work, volume of public financing and candidacies that occurred in both the June and the November elections. As a segue to identify 2 key activities that we'll be turning to separate and apart from what you normally see here before you regarding election-related work that the commission staff does. First is, as you know, there's a requirement in the ordinance that we provide a report every post-election to the board and mayor's office about the public financing program. And so that is something that we will be working to do in the normal course of things, summarizing information and data from both June and November, since we had both elections this year. That report we're planning to base on the final calendar year figures, so that will be based on reports that are semi-annual reports coming in at the end of January. So we'll provide that report and, of course, present that to you for informational purposes. And through that process, as we continue to issue spot, if there are other items of interest that we note there, we'll, of course, highlight those in the report, as well as providing basic statistics for the record year after year about the public financing program. And then separately, in terms of the required audits, you may recall that we did secure the support of the Controller's Office for the 2016 campaign audits of publicly financed candidates. And that is something that we are again securing this year for the June election. So the Controller's Office has agreed to support and provide support for the mandatory public financing audits for the 2018 publicly financed candidates. There are 5 of those committees that will be audited. And then we will be working with our team to do the audits of the non-publicly financed candidates, as well as remaining audits from the 2016 election. Because of this year's busy election cycle, we have yet to make further progress in completing the 10 remaining audits that have not yet been started from the 2016 cycle. We completed all the candidate audits from that cycle. We just have some committee audits that we selected at that time, so we're going to turn back to doing that now post-election. We will also be working to leverage funds that are available excuse me, funds that are available through the language of the campaign finance ordinance, that we can tap some of the election campaign fund for administration of the fund, administration of work related to the fund. We believe accountability for public financing audits is a piece of that. So that is going to be something that we'll leverage to help defray the external audit resources to help with the November 2018 public financing committees that we'll have to audit. There'll be 10 of those. So the bottom line is that now that the election is over, we're turning again to audits and hope to make progress on that front with taking some new approaches. And again, the continued assistance of the Controller's Office, which has been a tremendous resource for us. That's also a segue to where we are with hiring. We have been continued to be in the exam phase for 5 positions that have been in recruitment. We're moving from the written exam into the oral exam phase over the next month. I've detailed out in the report some information about how that process works. So we're attempting to be as aggressive as we can, given some constraints that we have for when exams can be scheduled with core exams that need to be taken. But we are making progress. So we'll look forward to giving you more information next month about where we are. And happy to take any questions that you might have for us.
With regard to the hiring, do you anticipate that you'll be able to make offers in the early part of the new year?
Yeah, I'm hoping that's the case.
So that ideally will be staffed up in the first quarter?
I'm hoping that's the case.
That'd be a wish for Christmas, right? For the holidays. Okay. Any other questions from commissioners on this report? Public comment? No public comment. Okay. Agenda item number 9. Discussion and possible action regarding status of complaints received or initiated by the Ethics Commission. Is there, we can take public comment on them and then go into closed session if there's a desire to go into closed session to discuss this. I think you need to. All right, we'll take public comment on agenda item number 9. There being none and no motion to go into closed session, we'll head to agenda item number 10. Discussion and possible action regarding probable cause determination for complaint alleging violations of the Lobbyist Ordinance, Article 2, Chapter 1 of the San Francisco Campaign and Governmental Conduct Code.
To clarify, agenda item 10 we placed on the agenda as a placeholder, but since no commissioner requested to calendar the report for consideration, agenda item 10 is effectively a dead item, and so there will be no action, discussion, or public comment.
Thank you. I was wondering what that was. Agenda item number 11, discussion and possible action on items for future meetings. Public comment on agenda item number 11?
My question is, what has the decision been made on the December meeting?
It will be held on the regularly scheduled date of December 21st. Yes, at 2 o'clock.
When?
A regularly scheduled date, December 21st,
Yeah,
Friday at 2 o'clock.
fine.
Okay. Public comment on agenda item number 11. Okay. Excuse me, agenda item number 12, additional opportunity for public comment on matters appearing or not appearing on the agenda pursuant to Ethics Commission Bylaws, Article 7, Section 2. Public comment. Okay. Motion to adjourn?
So moved.
Second? We're done. We're adjourned. Have a wonderful Thanksgiving, everyone.